Senator Kennedy.
Thank you, Mr. Chairman. Judge, congratulations. I'm not going to ask you to comment on any Supreme Court precedent or how you're going to rule on cases. I just want to try to, as Senator Durbin suggested, get to know you a little bit. You serve right now on the Los Angeles County Superior Court. Is that right?
Yes, it is. Thank you.
Is the Los Angeles County Superior Court, in your opinion, systemically racist?
Thank you for that question, Senator Kennedy. So I think that questions regarding racism, regarding systemic racism, again, are very important ones for policymakers to be focused on. I'm focused on my day-to-day work as a judge on the cases that come before me, and I think that I best serve my duty as a judge by keeping that rigorous focus.
I'm sorry to interrupt you, but we have so little time, and I've got several questions. Do you consider the court to be systemically racist? You sit on it right now, or not?
Again, Senator Kennedy, I feel that I best serve my duty as a judge by focusing on the individual cases that come before me, individual questions.
But the court is an institution. Do you is it? I mean, I think it's a pretty straightforward question. Is it systemically racist or not? The Los Angeles County Superior Court.
I understand your question, but I think that those kinds of questions are best left to policymakers, and that as a judge, that what I need to do is to focus on my cases.
You don't want to answer it. I get it. Explain the Erie Doctrine to me. You're going to see that a lot on the Ninth Circuit.
Thank you for the question, Senator Kennedy. Now, in my 14 years as an attorney, as appellate advocate, having handled many different cases, I never had a case regarding the Erie Doctrine. I'm sure I learned about it in law school. Yeah. I don't recall it sitting here before you now, but I'm certain that I'd be able to look it up and find the answer for you and come up.
Are you familiar with Erie v. Tompkins?
I am familiar with the existence of the decision. I'm sure that I read it in law school. I haven't read it recently.
Okay. All right. Name a public policy that you think is a good idea but is unconstitutional.
Thank you for the question. Given that I am a sitting judge and a judicial nominee bound by codes of conduct, I don't think it would be appropriate for me to comment on policies that I believe are constitutional or unconstitutional.
No, I'm not asking you to do that. I'm saying, tell me a policy that you like that has already been declared by the courts that's unconstitutional.
Thank you, Senator Kennedy. So I, as a judge now, and again, if confirmed, am bound to follow Supreme Court precedent. I'm bound to follow Ninth Circuit.
I know precedent. That, and I'm running out of time. And if you don't want to answer, I get it. I've got other questions.
Well, I'm sorry.
Can you name me a public policy? I'm not debating the legality of it. I'll stipulate that it's unconstitutional, where that you think is a good public policy regardless.
Well, thank you. But in my view, I am not served, and my oath is not served by me commenting about my personal views, because my personal views don't drive what I do as a judge, which is to follow the law in every case without reservation, right, whether I think something is a good or bad
I'm running
policy.
Out of time, Judge. I still don't understand any of your answers. Let me try one more. Here's a hot topic. Tell me the legal basis for a universal injunction.
Thank you. So injunctions are governed by Federal Rule of Civil Procedure 65. The court has said that injunctions are an extraordinary remedy, and I understand that they are. So the legal basis for a universal injunction or a nationwide injunction is whether it is necessary to give the plaintiffs complete relief, but without imposing an undue burden on
Is that case law or constitutional law?
That's case law.
And what's the cases? What are the cases?
I can't cite for you the specific case, but I've reviewed cases about universal injunctions and understand again that that's an extraordinary remedy, very fact-bound determination about whether those should be issued.
Okay. Thank you.
Thank
Mr.
you.
Chairman.
Next for questions is Senator Hawley. He's returned, and if no other additional senators join us, it'll be Senator Blackburn after him.
Thank you very much, Mr. Chairman. Judge, congratulations on your nomination. Thanks for being here. I want to come back to an issue that Senator Grassley raised, and I just want to be sure I understand your position. I'm thinking about these briefs that you signed in two different cases, one in North Carolina, one in Texas. Let me ask you about the North Carolina case first. You argued there that Title VII prohibits disadvantaging someone because of gender nonconformity, regardless of the birth-assigned gender or current gender identity. The brief also suggested that privacy and safety concerns underlying North Carolina's proposed bathroom separation of boys and girls are unfounded, and that the state had not demonstrated any public safety risk. In the Texas litigation, you said there was no data or tangible evidence in support of the claim that allowing people to use bathrooms corresponding with their gender identity will lead to crime in restrooms. Now, I have to ask you, in light of what we are seeing in Loudoun County, there are reports about this in other places, but it's particularly troubling in light of the recent events in Loudoun County, where a boy in late May was sexually assaulted a 9th grade girl in her school's restroom after he identified as being gender fluid. He was transferred to another school where a second assault occurred just earlier this year. Do you stand by your comments in these briefs that there is no evidence of violence or crime in restrooms by allowing biological males to use biological females' restrooms?
Thank you for the question, Senator Hawley. As I explained to Senator Grassley, in every case that I had as an advocate, it was my duty to represent the views of my clients. And that's what I did in those briefs, which were filed when I worked for the New York State Solicitor General's office. Now, I was not familiar before this morning with the Loudoun County incident, but again, what I would say is this, that I understand well, being a judge now, the difference between being an advocate, advocating for your clients, and being a judge who is duty-bound, who takes an oath, and one that I take very seriously, to apply the law to the facts and the record, and to review each matter individually as it comes before you. And that's what I would do were that issue to come before me, if confirmed.
Yeah, thank you for that. I understand that, and I appreciate your role as an advocate. I'm just curious if you stand by these comments. Do you agree still today that there is no data or evidence in support of the claim that allowing people to use bathrooms corresponding with their gender identity will lead to increased violence or crime in restrooms? I mean, do you think that that's accurate? You signed those statements. You filed that brief. Do you think that that's right?
Thank you for that question, Senator Hawley. Again, at the time that I filed the briefs, I was representing clients zealously, as I was ethically bound to do. In a new case on new facts, I would have to analyze it based upon what was presented to me, or if sitting on appeal based on the record.
Well, and I'm asking you to do that now. I mean, I think this is important. You were actually counsel of record in the North Carolina case. You signed the brief in the Texas case. Now, I understand you're representing clients, but of course, I also understand you have a duty not to sign briefs that you think are unethical or that misrepresent facts. So I assume you think that the arguments made in these briefs were correct and accurate. You wouldn't have signed them. Certainly, you wouldn't have been counsel of record. These are quite dramatic claims that you made in both of these cases. And now we have reports in various parts of the country, but Loudoun County most immediately and most publicly, about assault by a biological male of a ninth grade girl, and then a second assault happening. It's exactly what you said in these briefs wouldn't happen. I just wonder, what would you say to the parents of this girl who was assaulted in a restroom at school? She's in ninth grade. I mean, would you maintain to them that their concerns are unfounded and that they shouldn't be concerned about what happened? I mean, is that the message?
Thank you, Senator Hawley. Sitting here as a judge, my duty is to review the cases that come before me on the evidence that comes before me. I can't comment on a case that's pending, on a case that might come into my
Well, this case
courtroom.
isn't pending before you.
Well, I can't comment on a case that's pending anywhere per the California Code of Judicial Ethics. So the only thing that I can tell you is, again, that I understand that.
So you know, my time's expired. And I don't mean to interrupt you, Judge. I've got to let somebody else ask questions. I just want to be clear. So you stand by these comments. You don't think that you stand by what you filed in these multiple different cases. You don't think you were wrong about that. You haven't changed your view. You wouldn't change anything that you said and that you filed. You put your name to.
Thank you, Mr. Chairman. Judge Thomas, welcome. As I look at your record, it continues a pattern of the Biden administration of nominating individuals to the bench who have long careers as activists. Throughout the course of this hearing, you have explained some of your prior positions as simply representing a client. But when I look at your career, I don't see that. I see that you are passionately committed to a particular vision of the law. It has ranged from filing briefs in litigation in the state of Texas, defending race-based discrimination in university admissions, to most consistently transgender activism, and I would submit extremism. And this hasn't been one client you had in one case. This has rather been a consistent pattern that extended when you were a lawyer for the state of California, that extended when you were a lawyer for the U.S. Department of Justice, that extended when you were a lawyer for the state of New York. In 3 different jurisdictions, you have been involved in litigation on the extremes of transgender issues. And in particular, you've carved out an expertise for yourself using litigation to force institutions to allow biological males to use restroom facilities and locker facilities that are also used by girls, young girls, that are used by women. And this has been a pattern. When you were a lawyer for the state of California, you filed a lawsuit against Crunch Fitness, a gym, for not moving quickly enough to allow a biological male to use the women's locker room. When you were a lawyer for the state of New York, you filed briefs against the state of Texas, against the state of North Carolina, again, advocating for biological males to use girls' and women's restrooms. And you know, the thing I find troubling about these arguments is it seems the women and girls never have any rights. That the girls that would like to shower next to someone who is not a biological male, who would like some privacy, their rights never seem to matter. And your pattern, it's not a single case. It is across 3 jurisdictions over and over again. In the Texas case, the brief you filed said quote, "There is no data or tangible evidence in support of the claim that allowing people to use bathrooms corresponding with their gender identity will lead to increased violence or crime in restrooms." Do you stand by that statement?
Thank you for the question, Senator Cruz. Again, as an advocate, you advocate for the positions of your client. I haven't been an advocate for 3 years. I've been a judge. And when
3 years is not very long. And my question is simple. Do you stand by that statement?
Senator Cruz, it would not be appropriate or consistent with my ethical duties to my former clients to comment on my personal views about any case that I worked on. What my duty was to advocate zealously for my clients. I have set aside the advocacy role, and I now occupy a judicial role where what you're
Judge,
guided
your
by.
brief also contended, quote, "In states where anti-discrimination protections are already the law, the predicted safety harm has never materialized." You made a bold, aggressive, factual statement, by the way. In North Carolina, you said safety concerns were, quote, "unfounded." You were an aggressive advocate, an activist advocate. And I believe the statements that you represented to the court, and those are statements that you're making as an officer of the court. I believe they were false, and they are extreme. You testified to this committee that you were not aware of what happened in Loudoun County until this morning. I find that remarkable for someone who has spent years as one of the leading activists for allowing transgender biological men to use girls' restrooms and women's restrooms. In Loudoun County, Scott Smith, who's the parent of a 14-year-old girl, alleged the Loudoun County School Board covered up the sexual assault by a gender-fluid individual against his 9th grade daughter who entered the girls' bathroom in a skirt. And this individual was charged with 2 counts of forcible sodomy, 1 count of anal sodomy, and 1 count of forcible fellatio. The school district covered it up. They released this sexual predator, and the predator committed sexual assault again, twice. Why did you represent to the court that concerns about violent sexual predators committing violent crimes against young girls are unfounded and speculative? Why did you represent that to the court?
Thank you for the question. I advocated on behalf of my clients based upon the data that we had at the time, and I zealously did so in those cases and in every other case that I handled.
Were you right?
Senator Cruz, it would not be appropriate for me to comment on the merits of any personal views regarding litigation that I handled on behalf of my clients.
Well, these little girls who
Senator
were sexually
Cruz,
assaulted
let her respond. Your time
will
is
have
up.
a
Let's
very
let Ms. Thomas
different
respond.
assessment.
Senator Cruz,
These
let
little
Ms.
girls
Thomas
who were
respond,
assaulted.
please.
Thank you for your
Time is
views,
up.
but
You're past time. Let's afford Ms. Thomas an
she
opportunity to
is
respond to your
perfectly welcome to respond. But as I said, the little girls who were raped in
Thomas.
Loudoun County would have a very different assessment of whether this threat and danger is speculative or not, and you're more than welcome to respond.
Thank you. I will just conclude by saying again that I understand the difference between being an advocate and being a judge. I am a judge now, and what I'm guided by is the record before me and the law, and that is what I do now, and it's what I'll continue to do if confirmed.
Thank you, Ms.
Thank you.
Thomas.